Hello, Stephanie Joy with All Things Social Security. We had a Q&A with a short little clip discussion on a particular topic. So I'm going to attach it for you here. It might be something that you're interested in if you clicked on this header. And following that, we're going to go through it a little bit more. So just wanted to give you the heads up. This is where it started from, and then we'll have the bigger discussion right after. All right, chat with you later. Bye-bye.
After 9 months in a 36-month trial, okay, is there another 5 years in the case completely closed? I think you're talking about the 9-month trial work period. Then you have the what is the 36-month extended period of disability? Is that maybe what you're talking about? And then the 5, I'm not sure what the 5 years is. Does that make any sense to you?
No.
No.
I mean, the 5 years is a rolling scrolling period for the 9 months.
The 5 years is for the trial work period. So if you've exhausted that, but you're no longer on disability, in other words, if you've used up your 5 month, it gets a little confusing. If you use up your trial work period and you remain below SGA, you continue to get benefits. If you use up your 9-month trial work period and you go over SGA, they're going to move to terminate you. If you're terminated, there's no more trial work period because you're off of benefits. But if you've used up your 9-month trial work period and you've gone through, I'm not sure what the 36-month.
I think he's referring to the extended period of eligibility, EPE,
but that's
where you don't get terminated unless you do a successful work attempt. You could. But for every month you're over SGA, you got to send back your Social Security money. Be an overpayment.
Apply. Honestly, just to be straight with everybody, we don't really deal with that much. Usually people, they hire us to get on benefits. We could try to answer questions about trial work period, but after they've gone through the trial work period and they've returned to work, and then there's the extended period of eligibility, I don't really deal with that very much. Quite frankly, it's because, they just essentially go back to Social Security, is my understanding, and say, I'm off of work and please restart my benefits. There's really not a function for a lawyer that I'm aware of.
Right. Well, it would be like, if they've been ceased because they were earning too much, they can do that expedited reinstatement if they suddenly can't work again. Like they lose that job and they're not working because of their disabilities.
I just don't know if Social Security says, no, we're not going to return you to benefits, do you have the right to appeal it and then go through the whole?
Yeah, because I think it's I feel like the expedited reinstatement is really just a whole new, it's kind of
a new case.
Yeah, they just do it supposedly a little faster, but honestly, it's not that fast. I think maybe you go to the front of the line. They still order all your records. They still, make sure. So, and I have represented people on those, when I didn't represent them on the underlying, but then they, did what they did and
I really have not. It doesn't come up very much. I mean,
it doesn't. It's not often. It's definitely not often.
The thing we struggle with as attorneys, if there's no past due benefits involved, it's very hard to hire a lawyer because people don't have money to pay up front. Steph, you do some pro bono. We all do a little pro bono, sometimes involuntarily pro bono. But you can't stay in business if you're taking cases you're not getting paid on them. So it's hard to sometimes do a lot of that. And then again, some of it is just we just don't get a call for it. Just really don't get a call for it at all.
Hey, so if the subject matter of the video you just listened to is of interest and you want more on it, stay tuned. Here's another one about the same topic, but a little bit different. Bye now. Morning. So someone was asking what happens, and this is for people who are collecting Social Security disability and they are working part-time at the same time, and what happens when their 36 months of extended period of eligibility, EPE, ends. So just we'll get to it in a second, but just so you can catch up, if we start to work part-time under SGA, or not under SGA, but in any event, whether it's over or under SGA, but it is over the TWP amount, which is trial work period amount. We do 9 such months in a rolling 5-year period. We have videos on that. Once we hit that 9th month, the following month is automatically an EPE, extended period of eligibility. And that is a 36-month period. And what that means is if you keep working any of those months where you go over SGA, so it's no longer TWP amount, which in 2024 I think was 1110, It is now the SGA amount, which was $1,550 in 2024. We're breathing down the neck of almost at 2025. So for any of those months in that 36-month window, that 3-year window that starts the month after your trial work period has ended, if you actually got into your trial work period, you don't have to when you work part-time. You can avoid that altogether. But for those that have, they will be hitting their EPE. During the EPE, if they work any single month or more than 1 month above SGA, and again, 2024, that's $1,550 gross per month, that month of benefits that they received for the month they worked that much, they owe back to the SSA. And because the SSA doesn't really find out about it until a bit after, you're going to have an overpayment and something that you have to pay back. If you stop working under SGA the following month or 4 months later, then your benefits will kick back in for the months that you did not work SGA. Keep in mind, during the EPE, they can find that you are not disabled, and they can use the fact of whatever work you're doing. If it shows that you're not disabled, let's say it shows you can do something you said you couldn't do, be mindful that you're still subject to CDRs and all that kind of stuff. Okay. The difference between EPE and trial work period is that during the trial work period, you can still be booted off of Social Security disability due to not being medically disabled as per, medical evidence or what have you. They just can't use the fact of your work and that your work is over SGA potentially during your trial work period to find that as a basis for not being disabled anymore. When you get into your EPE, they can look at your work. So that's the big difference largely with trial work period and EPE. So what happens when the 36 months of the EPE ends? Let's say you went all through your EPE, you never went over SGA, you didn't know back any months, you were keeping your work very properly confined to under SGA. Once the 36 months is over, you absolutely do not want to ever go over SGA because that will be the end of your benefits. The extended period of eligibility gives you a little buffer. So that sometimes you go over, sometimes you go under. You only have to pay back the ones where you go over. After your extended period of eligibility, you are not, again, if you go over SGA, you're not later allowed to be eligible again on that same claim. You have lost your Social Security disability. So when we work, we really have to pay attention to what we're doing, our incomes first and foremost. I think it's really important to look at the substance of the work also, but that's a little more subjective in some ways. But the black and white numbers of what you're earning, it's really, really important to keep track. It never ceases to amaze me when someone says, I might have gone over SGA. I didn't realize. Well, what is wrong with you if you are working while you're collecting a benefit that you get for not being able to work substantially, yet you decide not to know what substantial means and go ahead and do it? Doesn't make sense. It's not wise. It's not an adult decision. So I think people need to pay a lot more attention if they're going to be working. I'm a big advocate of disabled people on benefits working and keeping their benefits when they do it properly. It makes for so much better quality of life. They seem to have a much more enjoyable private life when they work a little part-time. They're bringing in extra money for themselves, or if they have a family, they're contributing more. And it's just that whole, I don't know if I should use the word self-esteem, but it really goes far, I think, to such an extent that it probably makes the person healthier in the end. Again, assuming it's work that is conducive to their disabilities and it's not harmful to them. Which, of course, if you're going to do that, you might want to ask your doctor if you are not sure, if it would be dangerous for you, depending on what the job is, I'm sure. But yeah, after that EPE is over, guys, any month you go over SGA, you just put the fork in your well done case and it's over. And what happens is if you then drop below SGA and you still have those severe impairments that never really got better, you can file again. You can even do an expedited reinstatement request. It's kind of the same thing as filing again, but supposedly it's expedited. Supposedly. And that's what I would do if that happened. I've had people who purposely went back to work knowing they were going to get off of SSD, were able to do it for a couple of years. And then, as often happens when we have incurable impairments, as we age, they might get worse over time. So while they had a couple of years of improvement enough to go back to work, it then deteriorated. And we've done expedited reinstatements. Sometimes if too much time has passed, it is a full-blown new application. Not a big difference. Might be a hair faster in theory, expedited reinstatement, but I don't really know how much faster it is. I haven't seen them be very fast. Although nothing is as slow as it is now on initial and recon. It's a bit of a joke right now, but hopefully that's going to clear up in the next months or year or so. All right, kids, that's it. EPA, EPE, and what happens when you SGA after it? You lose your benefits. Bye now.